Shamak Israel
se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho ba ye den eman se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho ba ye den eman se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho ba ye den eman se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho ba ye den eman se wani kuma kokoda se wo hwe na wani nkum so a coalition center na kobo electoral commission for ho ba ye den eman
Shamak Israel Yehowa Elahenu Yehowa Ekad we ahata et Yehowa Elohika bika luvika uvika navashika uvika miyopika tode yashach Tode yashak in English in the name of Shamak Israel Yehowa Elahenu Yehowa Ekad we ahata et Yehowa Elohika bika luvika uvika navashika uvika miyopika tode yashak in English in the name of Shamak Israel Yehowa Elahenu Yehowa Ekad we ahata et Yehowa Elohika bika luvika uvika navashika uvika miyopika tode yashak
and your statement is fallacy of argumentum ad hominem. Obviously, Uncle School.
Okay, French.
Fallacy of Latin. Fallacy of argumentum ad hominem.
Yehovah.
It's simple terms. The statement is a fallacy.
Wow.
Fallacious. And your statement is fallacy of argumentum ad hominem. Obviously, Uncle School.
Okay, French.
Fallacy of Latin. Fallacy of argumentum ad hominem.
Yehovah.
It's simple terms. The statement is a fallacy.
Wow.
Fallacious. And your statement is fallacy of argumentum ad hominem. Obviously, Uncle School.
Okay, French.
Fallacy of Latin. Fallacy of argumentum ad hominem.
Yehovah.
It's simple terms. The statement is a fallacy.
The lives of the people of Agbogbolosyi matter as much as the lives of the people of East Legon or cantonments. Enti, yeba hano, yebesi toilets, amamu. Yebesi toilets. In all, yebesi 8-unit toilets, 4 8-unit toilets, 32 toilets in all among the people of Agbogbolosyi. Usori na uko toilet uya ubejari enyasa. Ubejari enti yebesi bath houses so akaho. Yebesi 24-unit bath houses and 80 in all. 24-unit bath houses. Said mubenya ebi mubeko na mujare anapa. Na mujare tu na Usori na uko toilet uya ubejari enyasa. Ubejari enti Usori na uko toilet uya ubejari enyasa. Ubejari 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 enti yebesi bath houses so akaho. Yebesi 24-unit bath houses and 80 in all. 24-unit bath houses. Said mubenya ebi mubeko na mujare anapa. Na mujare tu na ma.
You know what time it is. 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 You know what time it is.
This is what I pour this thing in. The tomatoes. The tomatoes is in. There is a tin tomatoes. Yes, this is the fresh tomatoes, but I have to reconnected with the tin tomatoes first. And who is saying that is soup? I used to I'll block someone who I'm going to block someone. See, I'm going to block someone who will never forget in his life. What kind of stupidness is that? Am I doing soup? Is this a soup? Is this a soup? Do you see this as a soup? If you see a soup, won't you see a soup? What is wrong with you? Are you stupid girl? What kind of stupid girl? What's is this a soup? And then Jimmy some plan or not? Myself, if you don't see, I'll slap you over there with that. Whoa. Who is backing you? I'll slap you right now. Stop stupid girl. This is what I pour this thing in. The tomatoes. The tomatoes is in. There is a tin tomatoes. Yes, this is the fresh tomatoes, but I have to reconnected with the tin tomatoes first. And who is saying that is soup? I used to I'll block someone who I'm going to block someone. See, I'm going to block someone who will never forget in his life. What kind of stupidness is that? Am I doing soup? Is this a soup? Is this a soup? Do you see this as a soup? If you see a soup, won't you see a soup? What is wrong with you? Are you stupid girl? What kind of stupid girl? Is this a soup? What is wrong with you? Are you stupid girl? What kind of stupid girl? Is this a soup? And then Jimmy some plan on what? Master, if you don't, I'll slap you over there with that. Whoa. Who's back here? Backing? Some plan on what? Master, if you don't, I'll slap you over there with that. Whoa. Who's back here? Backing? Master, if you don't, I'll slap you over there with that. Whoa. Who's back here? Backing? I'll slap you right now. Stop a stupid dog. Make her in the outside. You don't know. Master, if you don't, I'll slap you over there with that. Whoa. Who's back here? Backing? I'll slap you right now. Stop a stupid dog. Make her in the outside. You don't know. Master, if you don't, I'll slap you over there with that. Whoa. Who's back here? Backing? I'll slap you right now. Stop a stupid dog. Make her in the outside. You don't know. This is what I pour this thing in. The tomatoes. The tomatoes is in. There is a tin tomatoes. Yes, this is the fresh tomatoes, but I have to reconnect it with the tin tomatoes first. And who is saying that is soup? I used to I'll block someone who I'm going to block someone. See, I'm going to block someone who will never forget in his life. What kind of stupidness is that? Am I doing soup? Is this a soup? Is this a soup? Do you see this as a soup? If you see a soup, won't you see a soup? What is wrong with you? Are you stupid girl? What kind of stupid girl? Is this a soup? And then Jimmy some plan on what? Master, if you don't, I'll slap you over there with that. Whoa. Who's back here? Backing? I'll slap you right now. Stop a stupid dog. Make her in the outside. You don't know. I don't want to make that. You don't know.
So when you come, kokoda. So what you know when you come so Coalition Center na kobo electoral commission for home by den MI. So when you come, kokoda. So what you know when you come so Coalition Center na kobo electoral commission for home by den MI. So when you come, kokoda. So what you know when you come so Coalition Center na kobo electoral commission for home by den MI.
The lives of the people of Agbogboloshi matter as much as the lives of the people of East Legon or cantonments. Enti yeba hano yebesi toilets amamu yebesi toilets in all yebesi 8-unit toilets, 4 8-unit toilets, 32 toilets in all among the people of Agbogboloshi. Usori na uko toilet, uya ubejari enyasa. Ubejari. Usori na uko toilet, uya ubejari enyasa. Ubejari. Usori na uko toilet uya ubejari enyasa ubejari enti usori na uko toilet uya ubejari enyasa ubejari enti usori na uko toilet uya ubejari enyasa ubejari enti yebesi bath houses so akaho yebesi 24-unit bath houses and 80 in all.
All right, good evening and welcome to With Audio Respect Extended Version. My name is Kevin Ekobe Dutela. It's exactly 4:53 p.m. U.S. East Coast time. It's definitely 8:53 in Ghana. We are streaming live on our stations across the world. We are live on TV. Search for Loud Silence TV on Multi TV. Loud Silence TV on Multi TV. We are live tonight across Africa. We are also streaming live on Facebook. We have 2 platforms on Facebook. Search for Loud Silence TV on Facebook and also With Audio Respect page on Facebook. Loud Silence TV and With Audio Respect page. These are the 2 official Facebook pages we're streaming our show on. We're also live on YouTube this evening. Search for Loud Silence TV on YouTube. You can be part of tonight's show. Loud Silence TV on YouTube. We are streaming live on TikTok this evening. Our TikTok handle is Kevin Taylor _WADR. Kevin Taylor _WADR. We also stream live on radio. If you have an Android device, download Loud Silence Radio. You can be part of tonight's show. And also, if you have an iOS or an Apple device, go to the App Store, download Loud Silence Radio. You can be part of tonight's show. I really appreciate you being here tonight, Sunday evening. It's Canada 1, South Africa 0. Expected it. It took too long, but it's all good. Thank you for tuning in. Normally, we don't appear on Sundays, but it's very important that we discuss this matter before tomorrow. And it's got to do with a Chairman Wontumi Samurai Boy criminal case going on in Ghana. To be specific, the High Court. More development, Chairman Wontumi changing his lawyers, bringing in a new counsel, Atachia trying to delay the process, trying to delay the judgment, which is supposed to be put out by the judge on the 3rd of July. Some developments have come up. As you can see on the screen, our topic is so simple. Is the judge trying to free Chairman Wontumi? It's a question. And the reason why it's a question is because we are going to build up to the conclusion that Chairman Wontumi's lawyer and Chairman Wontumi himself, they are not supposed to be given that privilege. They are getting too much privileges in court. Today I'll be telling you about how the court has actually given Chairman Wontumi too much room, and they intend to abuse that room the court has given or has been given Chairman Wontumi from the inception or from the beginning of this case. Tonight, we will make a point. We will let you understand why it's very important that the Chairman Wontumi case, the judgment is pronounced on the 3rd of July. Or the same week, if 3rd is a holiday in Ghana, at least the 4th, the 5th, the 6th, the judgment should be pronounced by the judge. Tonight's show is going to be very educative. There are some documents I will be showing you, and also I'll elaborate on some things that have happened. We all know Atachia is the new counsel for Chairman Wontumi. The strategy is to delay the court, delay the judgment, and make a fool out of the court and also of Ghanaians. The Chairman Wontumi team are doing everything possible to push this case into legal vacation and also to avoid going to jail. My job here tonight is to break things down to you to have a clear understanding of what is going to happen from tomorrow. Remember, tomorrow, on this same Samurai Boy case, Chairman Wontumi's counsel, Atachia and Chairman Wontumi being caught tomorrow, Atachia has put a motion or application, I don't know how they call it, that he needs more time to read the proceedings from the day this case went to court, almost a year now. He wants to read every single document before the judge pronounces or comes out on Wednesday, on the 3rd of July with the judgment. The question here is, are written statements or written submissions very important? Do they play a vital role in coming out with a judgment in our court in Ghana? Tonight, our job is to educate, to inform, and also to make sure the right things are done. Ejumbre, wa wo hwɛ me every Ghana, baby wo hwɛ me nyame nhyraw, ɛna nyame nso nhyra me. Dwumade we etwegu ende Sunday, yɛde Nyankopɔn ase Canada ahyɛ a year, South Africa 1, but yɛfɛ no to nkyɛn, Ghana ho nsɛm nkyerɛkyerɛmu ɛna yɛbɛkyerɛkyerɛ me dwumbre ma obia atene ho ase ansana yɛsi ɛyɛ na wɔtwe a yɛbɛsimi. De nyinaa ɛfa sɛ Chairman Wontumi Samurai Boy criminal case a ɛkɔ so court a ɛyɛ judge a ɔte akonnwam ɛse ɛyɛ the 3rd of July no or the ɛyɛ judgment bɛba. Na yɛ nyinaa yɛnim deɛ ɛyɛ Chairman Wontumi ne tactics a ɔplay ɛne deɛ ɔpɛ sɛ ɔyɛ sɛ ne bɛyɛ a ɛyɛ judge ne ready so ɔbɛka ne judgment na ɛmba so. Na ɛndɛ nwumbre yɛde mo ba bɛkyerɛkyerɛ ma de kodie nti a ɛhu sɛ ɛyɛ Chairman Wontumi ɛne ɛyɛ ne team no ade a ɔmo si ɔmo bo sɛ ɔmo bɛyɛ. Na yɛbɛkyerɛ mo ɔmo ne yɛ bi ne nyɔma bi ɔmo ayɛ court a ɛbɛdu nda a yɛne ehu ne sɛ ɔsɛ court ɛhwɛ ne yie efiri sɛ Chairman Wontumi ɛne ne legal team no ɔmo abuse court anasɛ ɔmo de court ne metwitwi fam akyɛ. Nsɛm bebree esi wɔ court time a asɛm we start ya na ɛyɛ Apiakubi ɛyɛ the lawyer for Chairman Wontumi. Na yɛka sɛ abuse of court a ne nyinaa kyerɛ sɛ nipa bi etumi fa kotikwan etumi ɛbɔ ɔmo tiri mu pɔ sɛ ɛyɛ court no ɔmɛfa kwan bi so ebu court enimtia ɔmo de court ne betwitwi fam ɔmo ndi court mmara so sɛdeɛ ɛbɛyɛ a asɛm a ɛda court no asɛm no ɛbɛyɛ den emu bɛtwe na court bɛbrɛ na sebio nsunsansoɔ no ɛbɛyɛ nsunsansoɔ bi ɛbɛyɛ basaa ɛyɛ nipa a odifoɔ no koraa ɛyɛ accused person no yɛntumi mbua no fɔ. ɛno ne adeɛ a ɛyɛ Apiakubi astarte a ɔyɛ from bɛyɛ 1 year case we start here. Now saa ɛyɛ formation na Apiakubi ɛbɔ ɛyɛ 442 formation of delay tactics, formation of abusing the court no ɛyɛ deɛ yɛhu no sɛ Atachia so abɛpeke efiri baabi a Apiakubi egya no hɔ. Yɛnyina nim sɛ MPP ɛyɛ fo a ɔmo yɛ lawyers no dodoɔ no abɔn na titiri mpanifo na aya na omudi MPP fo ni mo court no majority time ni nyina no aya na adada ene sebio atro ene eniahomo nsemi no mo ye a omdigina court ende eye attaching a oye lawyer ema eye Chairman Wontumi no or the sebia betudwa na otwetwe mu se opese asema yebebua eye the 3rd of July bosumi ebisim no ompese beba so na emom court ema no eye na otwe nsia 6 weeks, that's a month and 2 weeks na ono fan kinkan eye den eye court senia asem start here omo ya toto oma no nsema yebusa ye ebesin de na mokai se eye asem we imbra apiakubi eye na adwene se obeyi eye den obetwene ho afiri asem no hu ma Chairman Wontumi akofa lawyer foforo no ruling bi eba so court judge no etna case no so if you say che eye apiakubi ekọ court so ka kire judge no say oni Chairman Wontumi enye adwuma biom eho na judge no na no asem bi etudwa na no asem no yakan wo hasa ende ye de nkrata foforo be kire onwoma bi ne amoate ase adekudie ntia judge oti asem so no eni se sebio oma ne ho kwan ana oma eye apiakubi sebio Chairman Wontumi ene lawyer ho kwan mo bu court no enimtia edenwumbre yebedi san komo no yebema Ghana fo ate ase adekudie ntia ye sa ne se eye attaching a wabedi eye Chairman Wontumi wabe ye Chairman Wontumi lawyer no oma bom tirimu po se ombe the court no eni metwitwi fom ombe dada court no na sebio eye judgment a ebeba so July eye 3rd no eye court no entumi enye den entumi fa judgment ne mba na omutimu po se omopese omtwe asem num sense ho edada asem nani se ne be ya eye on the 3rd no July no eye judgment ne mba so na akọ eye legal vacation che se eye court sebi edumbre bi so a omokọ ahome na nka be boso miensa ana enan no yentumi mfra asem no na mo firi sa asem no 3 months or 4 months be dunu na MPP fo atoma be wi a Chairman Wontumi abe national chairman we ene nsema ende nyumbre Ghana fo do no se eti ase ansa na sebi ochina eye Monday no aba adekudie ntia eye show we anadwi ene se eye ochina no eye atachia ene eye attorney general mkakushia judge no court na atachia ekokire mu court se ohia eye na wotwe nsia na saa na wotwe nsia no na odebe kenkan krata na ate ase ansa na judge no sebio ono atachia na atama ope no judge ne fa judgment ne mbra adekudie show anadwi ye pese Ghana 14 nyome bi ase ansa ochina mbekọ court no e wo sa ote de ekonase na ote se uhu se atachia a oye Chairman Wontumi lawyer no omabo mutirimu po se omopese sebio omose asem no na sebio asem no ye nwonwan ende nwumbre ye benya abotre na edwudwam ama Ghana for ehu no kre no now show we end 2 hours show a ye de kire nwoma bi so se ne be ya ochina no atachia ene ne client eye Chairman Wontumi the accused ene eye the prosecution and I say eye the attorney general who is the prosecutor no omkushia court de beba abontene na obia ate ne ho ase na ena sema beka na nwumbre no de be pese wadwene koso pa no ene the ruling ana time a eye apiakubi ekọ eye den judge nenim imbre bi na nsen akaka se onye Chairman Wontumi lawyer biem no ruling na judge ne bae no nsem bi ho ma ebehia pa eno ena ewo se sebio ochina no atachia eye Chairman Wontumi lawyer omokopie court anopa na eno na wo se sebio judge ne ejina so na sebio ode eka asem no if you say judge na nkasa no asem a ogina mbra so edi ruli eye apiakubi asem no sa nsem no ye de ehu ni se sa nsem no enchia ye eye nsem a eda ho ejina ne na so a wo se judge no ontwe ne ho mfiri ho intanye dwumadie ma Ghana fo nyina ate nsem na se se ne be ya ochina no de be free court aba no ye nyina no sebio yakoma ebeto eyim enti enyumbre hwamia. I would like to say thank you very much for tuning in. I'm very happy, glad to see you. Yesterday I was at the Philly Stadium. I saw a lot of people. I met so many Ghanaians. It was a wonderful day. I went to watch Ghana Croatia with my family. I really enjoyed it. We lost, but hey, the guys played very well. I believe that this is a game, and sometimes you lose, you win, and you draw. So no bagawaya. We move on. Now, Andra, no, in some break also, Emma, I like the vibe of Ghanaians, you know. Yehunya bebre, yesterday bebre. And I'd like to say good evening to Anthony Cabo. Anthony Cabo, Anthony Cabo, Michiano, a very nice guy. Would Mika ba men change and Bemo Tumrika ever catch him see in picture na you see the panche and Anthony Cabo can say me Mr. Pa also Kevin Kramer no one chere dia Mary and bibi a mepe and I'm so Anthony minim so pere to kramai to inti Andrew the energy he's a very wonderful guy, nice guy, you know, or you kramai so okay. The problem I got with him is say the party he's joining omojimi, and he needs to understand say also otwene ho free sa party nim na so okoso ne omonante a problem ebe bana brobom ma hye ne nkom. But Anthony Cabo, no, I know say he would think he would be smart to understand what I'm saying. A very nice guy, apart from politics, a very, very nice guy. Andrew Heko Mekakra, which I don't normally experience, but I think it's a out of excitement. Uhu Bema and who now open asem na juni ejuma. I know sometimes we Bema Krampa no humo. You feel like running at them and heckling them and all that. Inti Anthony Cabo, one of my best friends now. I had a picture with him yesterday. I don't have it. He took it. It's on his phone. It's about Miashiana Busano. Now I can say, oh Anthony, Kevin's on the picture. Is this still on your phone? Yeah, a wonderful guy. But Andrew Anakam Besoka, Kevin. Okasema cancel or Kramai. He's very excited about it. But Okasena Kopesoka Kramai part or pay or send your party and son or pay. I Kramai to Kramai Shua and Osaka Bakui, but I don't know my dream want to man. In Anthony there, maybe I'm going to be a Kramai Shua, Anthony Cabo, a nice guy. But I saw so many people there. I met Bolare. Everybody knows Bolare is my friend. That's right after the game. Krana or did your love. My friend crowd. Minene Kasakura or Jolof. Akoko be ori. Bema wi akoko wa wi akadumpe no ma akako. Just say me dim no me kan ho asem this year better the problem. So I would like to say thank you to everyone. I also met my sister. I met my brothers for a long time. It was nice. It was nice. My kids enjoyed it. They really like what they saw. So much love in the system, and I was also happy. It's one of those things. I like to keep very calm and quiet around people. Observe a lot, but I pretend not to observe. And Ghana for the some of you are funny, pal. But hey, you be juma. I obende juma ni babe. My team is saying now, inti Mama Fansha so. Now let's step back a little bit. This issue I can is got to do with a chairman Wontumi. Last week, what actually came up? A Wontumi Samurai Boy trial. Wontumi's lawyer Samuel Atachia has urged the High Court to defer judgment beyond 3rd July 2026. Now, citing the registry's failure to furnish him with the record of proceedings needed to file his written submission by the court ordered deadline of 23rd of June. Now, last week, Atachia said, they say, only the new lawyer, Emma Chairman Wontumi. Now, Sisiano, or no, I catch record to say, even though court, I catch and say, Onko na onko jinkrata na proceeding documents no na on study. In fact, nanka was a court no on the 17th of this month no. And I just think on a written submission be a free a year the defense counsel ho. But because Chairman Wontumi ebe catch a court to say ono a year Chairman Wontumi no on appear could be any maybe because appear could be Jimmy no. The court actually said say even though any mrem say or say appear could be back court ebe catch and say on Chairman Wontumi nyejuma because on the rented Chairman Wontumi and also or high or decides or render the services Chairman Wontumi into see and on the Chairman Wontumi nyejuma bi ma the court has nothing to do with it. But the court, out of respect for Apia Kubi and also not to look like they are preventing Apia Kubi from explaining himself why he's not a counsel for Chairman Wontumi, no, the learned judge actually listened to Apia Kubi's vague statement in court. Oh, we are not the answer to us. Okay, so Chairman Wontumi akofa a lawyer for attaching. What she said, I want to ruling Moses say. A year from the 17th, we move the 23rd. Now, a year attaching or the new lawyer for Chairman Wontumi, no, on to making sure send a written statement, no, or the aba. Now, remember, judge in that day, no, or a ruling be. Now, ruling here very important. The reason why the ruling is very important to Ochina Court or Moko and the Chairman Wontumi judgment, and say, judge the ruling, no, she was specific on some things. She was basically emphasizing on Nyamebia and to me affected the 3rd of July, a year next month, a year ruling. No, into those are not that ruling here very important. I'll say Yejina Adjune Ekosi. Obeka Saturday na Sunday, Kevin Ekas Asem because Ochina something might happen in court. And when I say something might happen in court, and I say meaning BBC, but I'm trying to let you understand what Chairman Wontumi and then the lawyers they are trying to do. I want you to understand what they are doing and why court is supposed to be very careful dealing with Chairman Wontumi and the lawyers, because the abuse of the court by Chairman Wontumi and then the lawyers from day one, it has been there. But the court, for some reason, Chairman Wontumi and then the lawyers too much room. And my fear is that at a point, sir, abuse Chairman Wontumi and then the legal team abuse the court, it will set a bad precedent. Some lawyers in the future might capitalize on the court's generosity. You see, the court, Samurai Boy case, criminal case, I believe said the court has been very generous. And when I say very generous, there are so many things that I can court, in Isanka or more penny money secret during the trial. But for some reason, the judge on the case decided to give the accused all the opportunities to exhaust every opportunity. Send a beya. Obinko jina baby nka say na me call court and actually I won't win lawyers because say you call court there were some things that were not in our favor and a court I believe we say the court has been very generous, but the generosity in a court a show Chairman won't win the lawyers they are abusing it. Now appear could be the status are abusing they have abused the court for a long time. Now there's one thing say court they decided say because they want to give Chairman Wontumi the opportunity to, at the end of the day, defend himself. Now, court, Anshe say abusing the area too much. There are other legal brains. There are other people in court. There are other people who are also facing their criminal trials. They are taking note of the court's generosity. When it comes to legal matters, there's nothing like generosity. What the law is the law. Basically, that's what I'm trying to tell you. The law is the law. That's why when people go to court, when lawyers go to court, they use acts. They basically base every statement they make on a precedent, on facts, because court is not a place to speculate. Now, the moment you give people the room to abuse the court, even you being generous, you are creating another avenue or window for somebody to also abuse the court. And sometimes in court, because judge way there, judge way on judge way, because the reason is that the moment you try to be generous, not biased or trying to allow somebody to walk free, the moment you try to let people feel like they also have the right to express themselves, defend themselves, the more you become generous, the more you do what? The more you create room for the court to be abused in the future. And that is what I have seen over in fact, since Chairman Wontumi case in start here, the council and our lawyers of Chairman Wontumi from Apia Kubi, ABC Atachiano, they have seen abusing the court, because the court allowed them to do that, Apia Kubi cry free hono, Chairman Wontumi Ekofa Atachian, he also wants to do that. And that is dangerous for Ghana's court. It's dangerous for the judiciary. It is dangerous because other people are watching, other lawyers are watching. Now, there are two things you need to look out here. Or see a judge ruling before Atachia was brought in as the lawyer. And secondly, how Chairman Wontumi, your static case way, criminal case way, na appear could be a lawyer, how they have abused the court to this point. Now, my main show idea. Recently, Ohona Atachia ever grantee interview. Right now, Atachia is the lawyer. Emma Chairman Wontumi. Team, stay with me. Sorry. Atachia be grantee interview, Atachia said, Samurai Boy case, 6 weeks will be enough for me to prepare my written statement. As we sit here, Atachia is going to go to court tomorrow and ask for 6 weeks. Almost 2 months. That is 6 weeks. 1 month, 2 weeks. Ninyana say, or see obeko court or china no pleading with the judge and say man is 6 weeks now on study case from day 1 court day 1 day 2 day 3 all the documents that were shared in court case management period a year witness statement or say judge na man is 6 weeks now on to me fan study and reading but remember say a man is 6 weeks not already sign your way no we rating submission after that, does it really matter here? Is it very important? Does it have any effect on the judgment? That is the question we need to ask. Say, am I touching 6 weeks? The question is, So 6 weeks there, the man no. Oh yeah, what is the end game? The end game is written statement or written submission or written address, whatever. And that is his opinion. Now at this point, does it really matter to the judgment? Does it really matter? Will it change anything? What did the judge now or case now about written addresses or submissions? Written addresses or submissions, does it really matter at this point? Now, before we continue with this 6 weeks, Chairman Wontumi lawyer attaching the strategy they are playing to delay the case, not for the case to even be judged this year, let's step back a little bit. Now, Mokai say case in question BBC, and these are some of the abuses I'm about to show you. Make sure case in question, senior Chairman Wontumi appear could be abuse court, for some reason, the court actually did what? The court allowed it to go on. And I'm not saying the court allowed it to go on in a bad way. The court basically felt Chairman Wontumi needed all the time to make his case. But court now allowed that, What Chairman Wontumi lawyer appear could be ABC Atachia did and say they abused it. Making sure say chance na court dia mom no be say no the be good court no hu fi the be say court no mumbu no. Now let's step back a little bit. This is a court proceedings. Me. Now proceedings we and this is what happened in court. It happened around the 3rd of June, all the way 3rd June. Satana case no koso. Now you see this document, it's public document. And media a court. You can go to court tomorrow, they'll give you all the documents. We can also publish this tomorrow. This is not Kevin Taylor's document. And this is a document anybody can have access to, a court document. Now, on the 3rd of June, Assembly CEO Court, that is how Chairman Wontumi and then the lawyer appear could be abuse the court, and so the attachia wants to do that from tomorrow. Now, that's 2 p.m. Date tonight, 3rd of June, and so accused persons A1 presents A3. Sorry, presents and represent A3. Now, the counsel, Dr. Justice Srimsai, or the Deputy Attorney General. Basically, he was also the lawyer for Ghana. Let's make it simple. Now, so we study should you see a timer na case in the course and see how appear could be what he did in court. Any judge be only abutre, any court be they don't want to even listen to Chairman Wontumi and appear could be that time ni no and ka ushebu pa na nke this case do this point. But all these things Chairman Wontumi and the lawyers, they never spoke about it. All the things they did against the court, all the deliberate action they took, no one say it was going to delay the case. The judge still had that had to accommodate. Ya nyoma could do point be judge bia say be one person be Chairman Wontumi the team ding person or quick no or judge asam no anka say be obegina sajo mani su nyina judge asam no but judge ni nya abutre o wiase nyina ama Chairman Wontumi Emma appear could be any Chairman Wontumi mo disrespected court on several occasions, but the judge still believes say it was a Chairman Wontumi enya fair hearing. Fair trial is very important because he is just an accused or yet somebody who has done it so far as we speak. But so when you now come back into court proceedings, now share idea appear could be deliberately or court. Na judge na cause the bufu. Now I say no. This is too much disrespect. Eya de nimtia no doso. Just say we lawyer pagini awudi Chairman Wontumi enim but dia wo ye no I say we need the ho na opese say ubu court enimtia na udi di Ghana for the atem. But what happened was that judge did not do anything. And when I said did not do anything, the judge could have stopped the case there and said, hey, Muni Bibia, the way you are disrespecting the court, and I want to go ahead and write my judgment. But the court accommodated them. The judge sat and did not even react until at a point, Judge said, no. The abuse is too much. You see, to the point, after Judge said, this is becoming like a strategy of Apia Kubini Chairman Wontumi. And to the judge at a point, in court, the judge made it clear to them, said, no, the disrespect to the court, the disrespect to me, the disrespect to Obiano, deliberately a counsel and as a lawyer, deliberately changing things even in court. Case management or to be back court, no assistant BBR, all of these things. Judge can say, you know, what shall say, appear could be no, or a lawyer be I just say on can I just say oh delay case no, because the technical judge will be a bias. Now actually the cell, person jelly chairman won't to me, and case in can do her. But this judge feels to say, Chairman Wontumi needs to be heard. Chairman Wontumi the witnesses are supposed to come. Chairman Wontumi, whatever is provided, we need to. But it got to a point you could see, say, Chairman Wontumi appear could be. They were deliberate in their actions. They wanted to abuse the court. Per se, almost say case, you know. And I'm doing this and I say that is the same 442 formation and at the end, attaching a pick free. They just want to delay the court. They don't want the judgment to happen. Into attaching is also called court or 6 weeks. On family study documents. Abra case near Kenwe. Now, my mention you see what court and why attaching to me. Respectfully to the court, without due respect to the judge, I believe Atacha is not even supposed to be heard tomorrow. That is what I believe, myself and my team. I believe, say, the disrespect from Chairman Wontumi Council 1, Council 2, no, it is too much. And the same strategy, the same thing Atacha Pesoye. And I believe, say, the court is not supposed to tolerate this. Now, Hadia, you see, when you read on the 3rd June proceedings, you ask yourself, say, but why was the court allowing this? Now, Mami Ridi Adewincho, this is what happened in court on the 3rd of June. Oh, sorry. On the 5th, right? Yeah. So, on the 3rd of June, Omoko court I didn't see any. So, on the 3rd, almost on the 5th. But the judge had to address adibia appear kubini Chairman Wontumi ababe pie attachia is doing same, and that is the most dangerous part in this case. Now, Hadia, let's take our time and go through what actually happened in court. And these are some of the things that attachia is asking for. And these are things that are documents that he can even go to Apia Kubi and demand. But because he wants to delay the court, he wants to abuse the court, that's why they are doing this. But make sure, before Ochina Omako Court. Now, on the 5th of May, 2026, this is 5th May, near June crowd. Now, they see a court. The accused person filed 2 witness statements out of the 5 witnesses they listed. Now, on the 6th May, 2026, the accused person filed another witness statement, making 3 in number. They, however, informed the court of their intentions of filing 2 witness statements in addition. The court conducted CMC on the 3 witness statements and proceeded with the trial with the anticipation that the 2 witnesses, the other 2 witness statements will be filed by the accused person before the end of cross-examination of the other 3 witnesses. So, omo file witness cases, witnesses say sa nipa we na your call case management no your person omo ba. So on the 6th, the accused person filed another witness statement. Remember, on the 5th, the accused person filed 2 witness statements. Now, out of the 5 witnesses they listed, inti na or say or nipa or witness statement 5 sebu wa file. Now, what happened is on the 6th, even though on the 5th, okay, I say 5, on the 6th, a buy, afi or say they can only file only 2. But during the CMC, that's the case management, they said they were going to file 5. Omobedu court on the 6th, they are going to use only 2. Now, means 3 now also file, famba. That's fine. The court allowed them. And then you can see, say, it was a deliberate thing they were doing. Oh, yeah, the nipa 5 November. Omuni ebe from our bad kim. Abeka omanu asem. Ne atoto omano. No maboa me with a Chairman Wontumi. Afiom could record to pena dani. Oh, yeah, the new pen ebe bande. Abra, bodin kai aye case management. Judge atia say, oh, nipa num ne bia and ombeba. Nipa num ne ya file. Ya be free we and the or chani a free we no. What they do, they say, omokoye sa meeting you no mudru court to pay. Na appear could be we change bibia. Instead of 5 statements, both are done 2 and I done 3. And this is what transpired on the 5th, on the 6th of May. Now, don't worry, however, at the end of the cross-examination of the 3 witnesses, the accused person had not filed any additional witness statement. Inti, go ahead still. And then they did what? They cross-examined the 3 witnesses from Chairman Wontumi. Now, the funny thing is, time cross-examining of the 3 witnesses, no, the accused, Apia Kubi, they had still not filed witness statements of the other witnesses. Now, the court cautioned the accused persons and gave them 7 days to file additional witness statements if they are so minded. Into my court bufuye, judge ni bufuye. And okay, say Apia Kubi. Sa anko fuye a wo say omo babe witnesses amache ma Wontumi. Me ame babe won yomo. Say omo empe omo asem a omo mbra no me file omo statement because on paper the CMC case management no actually say e also mbe file na yetumi ko enimo case no. Into my judge bufuye o court. And okay, say de mo ye no nyanse bi enim ye case ni nyina ho adwuma behind the scenes say nipa dodo say na ebe kasa we na beto ye beduru pe na wo Apia Kubi ni Chairman Wontumi enkofo wo so mbe kasa no na sebio ye hu bebi omonam omo statement so omo famba. How are we moving forward? And all this, the judge had the patience to listen. So at the point the judge said, no, I need to send a caution to Oma Jatum so mbe witnesses for Chairman Wontumi. Now, this is what happened on the 25th of May. So from the 6th, the 25th of May, something happened. On the 25th of May 2026, the accused persons filed a 4th witness statement in the name of Honorable Kobna Ochredako Mensah. The court conducted CMC on this witness statement and proceeded and adopted the evidence in chief of the witness. Cross-examination commenced. The mouth of the witness was sealed and matter adjourned for continuation of cross-examination. Right now, naka witnesses mienu Chairman Wontumi Apia Kubi be file. So judge ni ma sa caution no. A mu say judge ni bu fuba no. E no ba omde ba akoba so ye de ba akwa na ba akoro na Kobi Ochredako, the former Western Regional minister. Akwana de nise petuo no. Jibi no numwi no. So when the guy came to court, they see and they say, Apia Kubi mo making sure say won kasa. Cross-examination you better to a witness no. Apia Kubi any Chairman Wontumi buy no. Almost so effort strategy be say witness no. And he say obi na no kasa. Almost Selina no. Almost person be answer to anything. And that day no. Yentumi ndi jumebia or court. And a court case you know something. Let's adjourn. Yentu case ni sheda. They use another technicality to prevent the witness from speaking. When they were in court that day, Saturday ni so no, awosanka Kobi Ochredako Attorney General in Samano no, ono so to obudin yebusana, ono so person bekasa. Emma waste time Emma Apia Kubi use delay tactics for court. Eka say because of something, me client into me kasa because of Emma Akwano sorry Kofima yentumi antena case so. Emma judge ni sa to case ni sheda because the time not time na court. And remember, from the 5th of May, judge need to make nyadian abutre for all these things. From the 5th of May to the 25th of May, no, anka witnesses ni nyina anka cross-examine, but Apia Kubi deliberately or making sure say court no schedule no schedule no because he wanted to delay the case. He never wanted the case to end. And these are some of the things they did in court. And the ABPH attaching us so picky from here. So I had to say a baton. We echo kakra no da come away. Now we have a delay. So it's a delay strategy. Now the same court, I'm sure the court is here. They see any before continuation of cross-examination, counsel for the accused, that is Apia Kubi, person informed the court that, let me take this, before continuation of cross-examination, counsel for the accused person informed the court they had filed a supplementary witness statement in respect of the same witness. In terms of our court, I feel that Apia Kubi catch the court to say, Kobi Ochredako. Or the statement ayajia tuma yebe busa na no asem no Apia Kubi say was file another statement akasa statement no ho until say yebeje sa statement na tumu no sa Kobi Ochredako no tumi nkasa. But remember, answer na witness babet na dakem ne busa na no nsem no ye very BCMC judge no on it 2 lawyers no ehia behind the scenes no mo nyina age questions ebe busa nipa no atum ye wia na ye de ama court no eno na ye dru court ebe di hu nkomo. Now what Apia Kubi did and say statement na eye Kobi Ochidako edin kan attended in say eno na eye the witness statement attorney general ebe hweso adoto na no ade achi bi no betena court appear could be catch record say ne witness no esa another statement bi or person de saka the statement no meaning sa first statement na da ho no yentumi ndi ho adwuma yensan kɔ biem na yenkoya another CMC case management behind the scenes na yenfa supplementary statement in san kan the witness statement no meaning it's a clear strategy to delay the court. And all this while na judge no won't show any anger. The judge was still accommodating Apia Kubi. Kobi Ochirakuba first time almost Selina no mama nankasa Apia Kubi make excuses. Ade chibero metenasia Apia Kubi catch record say oh me witness no one sembi kan rempo afinti esade beka ho na eno no because court engine to munti they are not going to allow a cross examination omo pese court ne gin supplementary edien na asam ne saka ho ansa na yato aso meaning the delay tactics is in force. They just don't want the case to move forward. Make sure the delay on my yabedru na on my abuse court na and the court should not allow Atachia to even make a statement in court. The judge or the court should not even entertain Atachia because Adia Apia could be a year from day one basin. That is what Atachia is continuing. And it's also up 6 weeks, and when you give him 6 weeks, you ask for another 10 weeks. Now, Mamechiro abuses Nibi. Now, so when this happened, something now the judge started getting frustrated. The judge started getting angry because it looks like say the taxpayers' money every single minute we are judge we are basically paying the judge. Every minute we are general court, we are basically paying them. So the judge is like, you know what, the taxpayer, we cannot waste their money like that. We need to basically move on, do the thing. I said the piano, I appear to be chairman Wontumi ba witness cra witness about na document ya printed document obianum se we dey be some question or say witness so akai bibi inti esi no yentumi nkasa nde yemfa nkoka ho ansa na witness na kasa. Now the judge when something happened. Now, notwithstanding his so this is what happened. Notwithstanding this irregularity, the courts obliged and conducted CMC on the supplementary witness statement and proceeded with the trial. Inti appear could be by and so yes, I was statement be a Kobi Ochidako asa account and agree into a account and I consider no problem. Se mo pese supplementary e no de kan ho a court tena court mo gitu no so mo sanfa nka ho because we cannot make this thing delay the case. Yet to me must supplementary statement we end delay case into the judge was patient and the judge said, you know what, we whatever you want to do we will accommodate you. So the judge accommodated the Apia Kubi guy again. And also and the judge allowed that to happen. 3 times these people have abused the court. The judge did not say anything. The judge wanted the case to flow. The judge did not want to be seen as biased. Judge Bia said, he or she would not even entertain this nonsense. He would just move or she would just move. But this judge took her time or his time to be taking all this nonsense from Apia Kubi. Now, I'm sure they see it. Now, the judge decided to speak after all these things. Now the judge decided to speak because now I feel it too much. Oh, who said some to me 1 week I cannot. Now we are spending 3 weeks or a month on it. Witness to me across examining in a day. No, we are spending 2 weeks on one witness. So the judge started getting frustrated. Said no, I didn't know. And I said more abuse court. And I say, Mashallah, person must say, delay Ghana. So the judge says something. I'll say, I have painstakingly gone through the trajectory and conduct of case management conference in this trial, mainly because my attention has been drawn to a witness statement filed on the 28th of May 2026 in the name of Honorable Evans Adai, who intends to give evidence for and on behalf of A1 and A3. Also, when you say at Akinkan Case Management Conference, that is CMC, meeting on behind the scenes and Sani Abakota Bekasano, I'll be adding document bachelor judge. So when you be someone no. Also, when you say I study ako back ako check a case management conference or no accused any the prosecution or not say and when we say one witness a friend or Honorable Evans Adai or no na eba bema de evidence obema yabetutu no emana de evidence aba be defend chairman Wontumi and the third witness no or say the name on this witness statement is not one of the names listed in the list of names of witness filed by the accused person. Judge said, but enda yeba court no. Yenim said there are 5 accused people. The 5 witnesses are omo ba be den yeba be cross examine omo. In fact 3 ya cross examine omo wi aka 2. But osi yeba court no. Afa me hwen krate nim a papa ye friend no de Evans Adai no. Ni dinim. He is one of the people so I was who accused a lawyer and I said who Apiakubi. You need to make sure he is available. Why say what sabete say dipa we ba be kasa amache ba Wontumi. But you be do court in no. Sa edine what is going on? Judge say na Apiakubi di adwuma na wo ye ne sa no. Because nipa o say obeba betena se me atoto na no ama be protect a defend chairman Wontumi no. List ma hwemu nyina menya botra ko CMC, that is the case management conference. Mako study names I will list the breye say eno sankofo we na wo be from mo e de o ma betena dakem ema omo sebio yatoto ma no a omo defend chairman Wontumi. But me do court ya no sa brantie ni di nim die enti na wo yesa. The judge started getting furious. Because now it say Apiakubi any chairman Wontumi no omo ya madwene say omo person abuse omo go court na nimfi omo person case ni because omo dada court no. And this is something that happens so many times. Oh, and yeah, one day, oh, this is something Apiakubi in chairman Wontumi. Yeah. They never spoke about it. The judge did not speak about it. Even the prosecution and the AG never came out to say this is what Apiakubi is doing in court. There was never a day the Attorney General came out to have a press conference to tell us to say, "Yeah, Apiakubi mo, to the list, but say witnesses way on Bekasa near year from na judge." We never heard the Attorney General make this statement in public. All along, the Attorney General was also focused. The Attorney General allowed the court to deal with these things. But say Attorney General be or pay public sympathy. Or say, I'm for make chance Anka, this will be his talking point. Anka, this will be his defense. He will be all over the place saying the reason why the case is not done is because Apiakubi say the court document is they go and check court proceedings. But the Attorney General did not do anything. Because the Attorney General at that point, his focus was to get witnesses to cross-examine, to get the truth out of witnesses. It will say, I feel the judge no ya mean. Judge no technically the all can say Apiakubi a twa court n'entro. Apiakubi deliberate na dida ho e na o twa court n'entro. On person be de eye no. On person delay case no. Na yanko enim. The name on this witness statement is not one of the names listed in the list of names of witnesses filed by the accused person. It is not for nothing that the practice direction on case management provided those direction to be taken. Or see, enye kwa say ye case management conference. The reason tia case management conference and then say send ye be ya Attorney General person or the prosecution witness ba wo Apiakubi ubehu nipa kro ubehu omudin ubehu nipa dodo send ye be ya wo so Apiakubi what the prosecution accused witness ba yes ubehu nipa kro ni din or say enye sa kekenti na CMC Butai bi tarechire na sa wo beba court na ya meet na wie na betena court na de adefo fraba means wo no court no person bebu court no intina judge no to Apiakubi for say dia all ye no or say case no na ni da ho no obu court na nimtia. He is disrespecting the court like deliberately. Now who read the document where a court document you can go and ask, they will give it to you enya media. Now say obesa will follow proceedings say see court. After this, something happened. The same court. I mean, really, they see in Chiro. Mekaba be see the attaching so the same strategy Apiakubi taking and no be no taking the disrespecting of the court, abusing of the court. Say court and more opportunity to pay. They'll blow it up. Oma MPP lawyers way Apiakubi and attaching way 2 days. Obe said man could do 2 months. That is why we have to be careful because court you don't allow these things to happen. The moment we give room for that, other criminals, their lawyers or their counsels, that is what they will be doing. Ochina omoko court into you remember buta mejuja we mwachiro. Now, when you move ahead, this is what it says. The bedrock, I wanted to read this is the latter part of the second one. Change in circumstances to cause a witness to be changed, substituted, and added. It is for the accused person to seek leave of the court, giving reasons for same, and not the situation this court is confronted with presently. Judge Nika say, we are accused, lawyer, Apiakubi. na so person wo sesa witness and now say witness be u changing the din and now we the din from and now obi foforo be shema. You have to follow the right procedure. Unim send ye no court ya. But what appear could be a ne say obeka say Kevin Taylor na ebetena adaka mu ade bechi ye beba no na Kwame Amoako ye busa na o say o ende yan agenda case ne yankomra me hwehwe Kevin Taylor. Inti judge ne kachen said that thing now wo appear could be wo ye no o gu court ne ma say o disrespect court no. In fact court ne chance or the amount say be the lawyer for Chama Wontumi na to me a protect and as a defender no. It is looking like say what the sa opportunity no what the abuse this opportunity no. It's judge ne call point to explain to him say yenya ne sa adia wo ye no enye wo na wo ma case ni delay because we are not supposed to do these things. What the witnesses list ba also making sure so we diso but to me court now witness list no ebi ayra obi din nim enti na judge na kire say ye adwuma say court mra no ho wunim dada so obese say obi krampa there is a way you do it. There's a way you go by it, but you just don't appear in court and say me change way without any formal approach to it or formal a way to approach it. It's not judge say no. What is going on? Who say case no? Who disrespect the court no? Who abuse the court no? Now, mommy unko so any unko who dey see your court. Now, the bedrock in criminal trials, Judge Nekasano, the bedrock in criminal trials is fair hearing. However, this should not be translated into an abuse. Inti judge say, "Hey, apia ku bi ni chema Wontumi nti ase. Nyoma moye bebre mama mo chance a sebio mu bu court ne abomfia, mo disrespect court no, mu delay case no. O say, saa nyoma na media mama say Wontumi emfa nka mo asem no enkyere say mu betumi ebu court ne nimfia ana abomfia, mu betuma disrespect court no. O say de mi wi kyere say saa na mo pese mo ye. Or say yema obi fair trial yema obi ho kwan say ono so en defend no ho onfa konfombra be defend no onfa adanse fombra be defend na say court ma ho kwan na court enya abotre na court anya okeke en kire say ubetum the court ni metwitwi form it judge ka say wo apia kubi woni Chema Wontumi ene saa eye the accused person ade a mo ye no emwaye saa nyama we nyina si wo court. Did you ever hear Apia Kubi come out to say court no did you ever hear the Attorney General come to say, this is what is happening in court? Apia Kubi abuse court. No? The Attorney General did not have time for that. The Attorney General's job was to get a witness to cross-examine, was to get to the bottom. If there are there are things happening in court, Obi abuse court. Now, it is not for the Attorney General to say. The Attorney General can raise objections and raise concerns in court, but the Attorney General, it is not his duty to make sure, an accused lawyer follows rules and regulations or court proceedings, the regulations. It is the court. Until right now, the judge is talking. The judge is frustrated. The judge has seen, Apia Kubi, any Chema Wontumi no, almost shut down on person who go court, and say, delay case, until all the way from May, they started delaying this case. So, case where attaching Abesomi, nan can you say through June? So case we don't can say enter June. Apia Kubi ade oyeye because from day one not almost strategy. Delay the case. Now Judge Nesaka Saya or say the bedrock of criminal trials is fair hearing. Now at this juncture, Judge Nekasa Muntieno. This is all the way in May. The judge started getting frustrated with Chema Wontumi Apia Kubi. All the way in May. Now Judge Nekasa say at this juncture, the court does not know whether or not the witness statement it has received in the name of Honorable Evans Adai is an addition or a substitution. At a point, now, I feel Apia Kubi akofa statement for Fraba. I feel that court now confused. Evans Honorable Evans Adai na oka witnesses no ho. I feel bayani dinim. Afia saba court Apia Kubi akofa sa nipa na no asem de aba se yemfa asem we nhye na je say right now dey na wo ye no list out the brain na ko edi wom afia pie court na di nim yesa wo court was akofa statement bi aba se e akwa ne statement ti judge say onim say or substitute akwa na free case ni mo say o de obi be hye mo right now the judge was confused e dey na Apia Kubi ye no e dey na Chema Wontumi ni Apia Kubi I so money da ho na o ma ye say o mo be book court nim ti o me delay case no. This is May. And remember, before May, no my assignment way be my judge and bibia. But you see, anytime they walk out of court, no matter catch a case in there, bibia judge na do some time. They knew what they were doing from day one. Deliberate delaying of the case. I idea from day one, not omunim de omoye. Now, when you move forward, Judge said, I do not think this sort of practice assists the court in the smooth delivery of justice. TNA, Judge said, I do not think this sort of practice assists the court in the smooth delivery of justice. I said, the appear could be no, and the chairman want to moya court. There be no makase, no mu delay court, no more. I say, sad dear way are more no. Menya sure say mo pese court no edini djuma se ne wo say edini djuma. I say mo timu pobi say court djuma die no mo be say no. That is the statement of the judge. So the judge got an idea of what Chairman Wontumi and appear could be no more ye. And it's on one case no master no say me hu say mo ye bibi say mo pese mo say case no mo pese mo delay case no unnecessarily. Mo pese mo shada na case we no eye tintia na nipa ehun say de ekọ. Judge no got frustrated. Remember, Adewe has been going on for 5 months. The judge did not say anything. But it got to this point. Now, it appear could be too much. Appear could be the other court, And you see, say judge be our body trimu possible be di bone. Now, or time chairman won't me. Case we can do me. Anka case we no. Anka say by a match. Now, say judge no. But you see, the judge and the court accommodated all these things. These are documents. These are some of the things they did. Now, Judge Nicole Nimno. Judge Nicole Nimokasemi or say CMC, Case Management Conference, is to give direction and clarity to all parties in a matter and above all, avoid surprises. Or say, Sa CMC no mo a Case Management Conference no ni nyina say yebeko court ochna. Krata bi Attorney General Edeba bebusa Chairman Wontumi and the other accused or say Attorney General the judge in front of a year appear could be a nim. And as appear could be so and a baby sebu or better to a year Attorney General witness anwa or saying krata or bebusanina or the banner judge no send a bear yen quarter or being of a krata be fra bontinimba Emma a Attorney General because appear could be krata with the one fan chess or bebusami witness once or say CMC no nijuma dienina no. Na ya den yakwa CMC ni ebeba na apia kubi ashada dan no won say de onim say CMC na odin krata foforo nipa din foforo statement foforo o say sa nyoma na apia kubi ye no washada. Now uku edima judge this akasa o say so when an accused person in the middle of a trial without leave of the court decided or decides at will to change witness in improper and this is stated with caution to the accused person, the 1992 Constitution grants rights to all persons, especially in criminal trials. However, these rights should not be exercised in a manner that will degenerate into a pattern of abuse of the rules of court. And a judge ne kachire eye dein, o kachire eye apia kubi, ene chairman Wontumi say, "Munim bibi. Dia mo ye nyina sebio 1992 Constitution eka se nipa bia wo ho kwan se sebio yenka ne kashaboa enhye ne yem obetumi aka na adwene obetumi edefend no ho obetumi afro obi amanaba abeya adansefo amano o se your constitution kire se obia wo ho kwan se sebio obenya fair trial obetumi aka na adwene aka no nokre ma yetie no o se na saa de na ewo ho constitution mu no saa eye tumi na constitution e de amaye se Ghana fo yebetuma fa lawyer yebetuma ko gina court yebetuma ka se oh sebio we de menya hwe nipa we no wo bi we na madance for no o se saa to be na constitution na Ghana ni bia no o se opeso o ma apia kubi ene Chairman Wontumi muti ase se from nyoma o ma ye a o ma hyeda ebu court nim tia ebu eye de constitution nim tia ema apia kubi continuously wa hyeda eye de abuse court no see saa nyoma no sebio so muti ase se ade bi o maya o de ni atofo mehu se e follow pattern bi ade bi ade se utumi tena hu se we ni ade bi o ma form ho adwene se o mo beye o se saa de na den o mo eya abeye o musuban ene o musu no sebio ono oya judge no ohu ni pain face se apia kubi ene on pese obebu court no Chairman Wontumi a oye accused person a wakofa apia kubi no oma bom tirimu po se court no bebu court nim tia omo de court nim twitwi fom omo be say asem no omo be slow asem no judge na asem okan no say sanyema amuye e wo be constitution defend obia but I say they said obia hu tirimu po de mo ye makama no atum ahwe wa we apia kubi we panyini why a lawyer check. But I say why should that say per se ubu court in tia. Me judge me me nipa. And also me tia ubi asem. But I say from time ongoing, time coming no. Why say adia why ya no. Na saa de na wo ye no e kire pefe se wunim de wo ye why you say obebu court in tia. These are judge no words and yet these are not my words. Now, Judge Nikodem now say, having cautioned accused persons, now this is what the judge concluded on. Now, court concluded on this. Having cautioned accused person, so it means the judge actually cautioned Apia Kubi. Cautioned Chairman Wontumi, said, you are abusing the court. Court na mama found kakra se mo fandi modwuma no mo pese mo de eden ebu court denim tia. Enti for a judge to caution you, it means the judge has had enough. For a judge to say dia mo ye no muntwa so. Mama mo time too much, and from proceedings you didn't see Apia Stadium Apia Kubi object to it. Apia Kubi never objected to the statement the judge made because no one said true, and the judge did not say anything out of what is happening in court. Saying Apia Kubi, the judge ne kano, Tananka judge ni chatra. Apia Kubi would have objected and say, "My lord, this is not true. I never did this. I never did that. I will never." But you see, because Apia Kubi knew what he was doing. Because Apia Kubi don't him say or person delay case no or person abuse court no or person disrespect judge no or person judge ni bufu na judge de bibi no, he knew what he was doing. Anything a judge no question no said the omo ye no a follow party bi omo njai no, Apia Kubi didn't raise any objection. Now, having cautioned the accused persons, the court will exercise its discretion and adopt the witness and the witness statement as if the witness was listed as one of the witnesses and conduct CMC on same. Inti Apia Kubi, omudi honorable ada any statement in the baya na at the end of the day, na nkeni say Apia Kubi the far back door, the be court ni kaso ni bibi. Apart from all the things you have done, inconsistencies, abusing of the court still judging say meji ni statement no. Mesa aba CMC. So the judge was not even supposed to do it. Because one, the witness now Apia Kubi edebano. In the first place, where you witness the dear film, and in the second place, the statement to that background, Sebi now witness didn't sign yet, and ya Paul Sanka court, and so judge Nikazoni Bibi. Upon all the disrespect, most show me or court her. Upon all the disrespect, witnesses show me. Upon the things you are deliberately doing to delay the case, still, remember the chance. Come to CMC, that is Case Management Conference, and come show me this new statement you have brought from nowhere, and let the Attorney General be here. I'll be here. I will look at it. I'll give you the opportunity. So you see, upon all the disrespect Apia Kubi show judge, still the judge gave Apia Kubi that respect. Upon the basic deliberate mistakes he did, they're deliberate. They make it look like it's an oversight. It wasn't an oversight because judge not judge me for. And Apia Kubi Debi Okacham say, "Oh, experienced lawyer. He knows what he's doing." So the judge knew from day one what Apia Kubi was doing. But you know what? Anka judge Bianco about the timu pose or time Chairman Wontumi anka that day na kobe in the case. Yeah. Because those were not Apia Kubi and not Chairman Wontumi, not only witnesses biabium. But you saw what the judge did. The judge said, "Still, I will give you the opportunity. Remember more chance. Somebody Evans Adai we come one. No problem. The statement from nowhere, we don't know where it's coming from. No, I'm going to adjourn my case, meet you at CMC for you to explain to me, for the Attorney General to be there, for we all to understand each other, and come back again and put that person you want to put in the box for cross-examination." The judge still accommodated this guy. The judge on the case still accommodated. You see, in law, you don't allow perception to take over facts. And especially when it comes to criminal cases, when it comes to politically exposed people, when they are standing criminal trial, especially when you have an opposition that can create accusation out of everything. We have people who don't really follow facts. When you're a judge on a case, what you do is you give people the benefit of the doubt. It does not make you weak. It's what it does is that it makes everybody understand out of your courtroom, because and you'll be in a raw courtroom. What it does is say that leniency, that room you give people you even think are abusing the court. When you do that, what happens is you make the case more transparent. You don't give people the room to go out there to insinuate, to create an impression, because you see, perception when it's attached to a crime or a case in court, it basically dissolves the potency of the case. So I think what this judge was doing was that she didn't or he didn't want to give anybody any room to say the accused person is being treated unfairly. Even though there were some things that this judge was supposed to stop, there were some things this judge was not supposed to entertain. A lot of abuses and disrespect to the judge herself or himself or the court, the judge was not even supposed to allow for some reason, because the judge wanted Ghanaians to understand that this case in court is not personal. She has no personal issues, or he has no personal issue with the Attorney General or even the accused. And that the judge's main focus was to make sure that this case, at the end of the day, whatever the accused has to present, they present it fully. And whatever the prosecution have to present, they present. So the judge was basically avoiding that perception that the accused person is being mistreated, the accused person is being gagged, the accused person's lawyer is not given the room. But you see, but the more lenient, the more diplomatically lenient the judge is, the more advantage Apia Kubi and Chema Wontumi were taking of the court. So you see, now when you give people the room to protect themselves, you give them the room to basically be heard, they abuse it, they take advantage of it. So we are judge and Kaden and Kobe. But all these things happen in court. All these things happen in court. None of us was told about this. But these people are the same people. Right now, what is Atachia doing? Atachia is doing the same thing. But I'll go back to the ruling. About what happened in court. Nobody will accuse anyone of being hard on anyone. And it's all share and I will study there. My dear you can see clearly say from day one, Apia Kubi or Shadan or abuse case, or abuse court, and a delay case. Now, shall you see it? Judge Nikasawi, Apia Kubi Ekasaya, what did he say? I have a friend in Canada. He just texted me. He just told me say I should call the witch doctor Kukubunzam. Canada for any day. Xavier Kukubunzam. Xavier, I'll call you after the show. Now, Judge Nikasawi, Apia Kubi also responded to what the judge said. Eden Okaye. Or say, counsel for A1 and A3, that is Apia Kubi. Or say, we have a witness statement of one Honorable Evans Adae. It was filed on the 28th of May 2026. I pray that the said witness statement be adopted by the court as a witness statement of the said Honorable Evans Adae. So, formally, I feel na all catch the judge and say, sir, witness na. Judge Niko CMC some time back and then the Dioma Apia Kubi muyi free muno. I feel na Apia Kubi because I feel the witness no edi ban the statement inti yanko CMC ni yanko discuss biem. So you see, anytime I'm just say if Apia Kubi had an issue with the judge's pronouncement on the delay tactics, on the disrespect and abuse of court, and Apia Kubi be raise an issue and say, Your Honor, or whatever, your lordship. In fact, what you are saying, without due respect, is not true. But you see, Apia Kubi didn't say anything because what he has done, abuse court, what if the judge did not have that patience, was not professional enough, has no interest in the Obika, just focusing on the case, and I can judge and react here, and press conference and Apia Kubi Babe. Imagine the judge threw out this their witness statement out to say we have gone to CMC and that we came to court and you're giving us a different thing. Can him the Apia Kubi? Do you know the kind of impression Apia Kubi Chema Wontumi they would have come out to put? Can him the Kofi Benton Babakano Abontene? Can him the MPP dogs? Do you know how they were going to narrate that? But you see, the judge being an honest judge, not wanting to take sides, listening to everybody's piece, the judge still gave them the opportunity. And anything appear could because, Madam Judge, Mr. Judge, please, now we want to formally drop the witness statement. The court should adopt it. We should go and have CMC. Remember, Sankadia or Yen first, and Kayan Sankobako, meaning the case has been dragged back again. This is all the way in May. They delayed the case for about 3 months. No reason. Now, so that is what happened in court. Makacho said this document, if you want to get it, go to the court. It's there. These are court documents. Now let's come to what happened in court the day Apia Kubi. The day Apia Kubi called court. Eko kachre judge ne say onye lawyer to the Chema Wontumi biom. Now, you see this. Right now, you know the abetted say ochina attaching say oko in court. Didn't know court oko pray for 6 weeks. 6 weeks in any day, or see a free be witness written submission or written addresses. Those submissions, no, you di asem we are. Lawyer bia odi a client enim no. You will share your opinion on asem na utinemu a lawyer for somebody no. The accused lawyer etinim etro and I said the prosecution lawyer no. Now, judge no a really a year appear could be case no that day no. Because that day na appear could be called court so oko catch the court to say on your lawyer to chairman Wontumi be no. Judge ni tie ni nsem nyina no. Na appear could be argument nyina say judge no twintwen so. Because we you know free say on your chairman Wontumi lawyer be no. Chairman Wontumi ko for another lawyer until my judge no enfan the judgment mba. And anything appear could be called court that time. So the reason why appear could be called court no. Nani nyina say okoka judge say menya chairman Wontumi lawyer be even though wash a date out of judgment mba no. Me make appear could be person wo twintwen wo judgment no so because mean enyame na mebetro written submission no media me ko obi na eba abetro. The question here is dey na judge ne ka that day na appear kubi eba court beka say onye lawyer to chairman Wontumi biem. Now in fact because onye loyalty written submission no judge remember am for the judgment mba. Now because enye on na betro written submission or address na say lawyer for bar which is attaching on the betro. But the question here is the written address and not submission from the lawyer after the case has ended. Not judge actually judgment, you know. Does it really affect the case? In normal law, judge it's not kunjuma. So the phone way ba and no and a judge no esha hon edi bua nasem. Say what the pen way ba and no and a judge no esha hon. Say accuse no the pen way ba no ka say any evidence and no na judge no she. The judge is just looking at the pen. Now say accused no ed way ba no can say wait me evidence that the judge is just looking at this. Lawyers mienu a omudi accused and also whatever enim no lawyers omo ho no the accused lawyer and our prosecution no the omo dwene efa asem no ho no their personal opinion which is the written address no at the end of the day is it an evidence ebetumi affect the case nana. It is two teams abo enra Croatia ashe Ghana 2-1. Now, two teams no el field in the Super Bowl. Your FIFA or manage the whole event. There's a referee in the middle of the game. Two assistant referees. They are match commissioners. Ball na ye no pitch this no. There are rules. Now, your ball ni wie. Ebia Ghana ne England the boy and obian shibi 0-0, right? There were some nyome bia esi or pitch na so. England goalkeeper na free in the boxing ebe tackles. On a normal day, ushe FIFA rules, any game rules are a red card. The keeper left the demarcated zone also odini juma wum stepping out whether he touched somebody or touch a ball cry at the end of the day yellow card and a red card. So otumi ko ball cry out of his box. Na and oni hu kwan se also kwesa na ko tackle obi na obi tough ma that ref keeper no so nensa kan ball nensa kan ball nensa kan nipa red card. That's how it is. Now Ghana say another chance. Na omo kose na in the box a defender a clamp Ghana a player down. Na we nya ball no because he needs to defend. He needs to clear that ball. So na yanka ball no na the player who is attacking goes down in the box. It's a penalty. That's how the rules are. Now, Sanyama when you see your pitch so referee jim, assistant referee so commissioner so yen FIFA president put to na ye wie na referee no ball aben mu say 0-0. Whatever the coaches say at the press conference does not change the final score. After game, the coaches can meet the press 50 times. Whatever England coach after the game, after the 90 minutes, plus other time, after the game, what matter? The see or pitch, their timer within that 90 minutes and time added on. So 90 minutes, that is what the FIFA regulations recognizes. So Ghana coach Nikoye press conference 50, and then he speaks about how he's disappointed in the referee. Now it will not change the goal line, the score line. It will not change the point build up. So England coach Nikoye press conference 50. Now, say Ghana coach journalists for Shannon and say, "Oh, Mr. Coach, how did you see the whole game?" His opinion about the game, how his team played, how the opponents played, the tactics he played, how the opponent. It does not affect the final outcome of the game, because the final outcome, the coach's ideas and opinions does not matter. The final, what matters is referee decision take and the score line at the end of the day and the point everybody got. Our coach can express his views, and in law, the Atachia is a coach. Now, in the middle of the game, FIFA himself, Brony Wayne a coach. Now your ball game na mani bedu 80th minute. Now Brony nika se niyemi na ya. Na se o free pitch na so kofie. Na se another technical person ebe som se on a coach. That person's opinion on that game. Say your pawn game na sa coach no be take over from Ghana coach no. So in a press conference on to me say I don't want to accept the outcome of the game because I took over from our coach who wasn't feeling well at the 78th minute. It does not work like that. So, sa coach na obeji baton free the sick coach wana obeye coaching for the next 12 minutes or 22 minutes. The issue here is FIFA does not care. The referee does not care. What the referee cares about is the game has been played. It's your point game, Now your coach now obesomu from the 72nd minute, the 90th minute. Eka say he feels that he was not in charge of the game from day one, and so FIFA should reverse the points build up. FIFA should reverse the game for us to replay the game, because time again they started on the Gina touchline. That is what Atachia is creating here. FIFA recognized the game that was started under the first coach. FIFA recognizes that Ghana had 11 players on the pitch. FIFA recognizes that there were referees refereeing the game. There were match commissioners. Whether you want to change your coach at the bench or not, it does not affect what FIFA, that 90 minutes, he has basically put together. Now, Atachia is saying, Onona ebe taking over from Apia could be at the 87th minute. Now, 3 minutes. Yeah, the other time, Okrabe Kahun. Emma obedru ya no krampo no na 90 minutes ni abowie. Emma referee the 3 added minutes account. Now I see because oba no na yabo 90 minutes na wie no 3 other times so ono Atachia on recognize say a FIFA official time. Inti now no yensan go back and go start the game because sa 3 minutes na it does not go by no ono recognize sa 3 minutes no. This is what they are doing. And that is what Atachia is saying. Say he is going to court tomorrow, and that when he goes to court tomorrow, he's going to ask for 6 weeks. 6 weeks to do what? 6 weeks to write his submission. The question here is, your press conference will not change what happened on the pitch. Your press conference wasn't part of the rules. Your press conference, it is not what FIFA is looking at. FIFA is looking at what the referee basically at the end of the day saw as good or not. Inti Atachia right now is saying, say, now, wabano, sa game in a course, we should go back there for documents in Yinama. We have 6 weeks. Now, let me show you something. Now, this was the ruling. I want all of us, and I've read this thing here about 3 times. Time Atachia, time Apia Kubi, Eko Kachire court to say, Onye lawyer to Eyadi Chema Wontumi Bimno. He went there. Thank you very much, team. I will add this to it. I think did you add this? Did you send this before or you just sent this now? Now, time appear could be muka say or court kakache court to say on person be chema Wontumi lawyer bimno. The judge said something to Apia Kubi. And it is very important because and I was a judge, she or he needs to stick to. Now, yanko time Apia Kubi court kokache judge and say or no Apia Kubi no onye chema Wontumi lawyer bim nemum Atachia and ebe chema Wontumi lawyer. Now, the judge said something that day during the ruling. Now, during the ruling of the judge, I have it. I'm trying to move it to the system. Thank you. During the ruling of the judge, Okabibi, and nona me pese ochna, the judge must, with all due respect to the judge, with all due respect, I believe the judge should or must stick to those principles. Because I have seen, say, MPP for any attach yamono, omo pese omu delay court no. They say they just want to delay the court. They just don't want the judgment to happen. And with all due respect to the judge, we want the judge to stick to principles because so far, judge na prove say or your honest judge and yet personal issues in the case in so. And yet obi no tano or pese obi that fair hearing. I believe say ochina before a judge no ebetie attachia. Ghana for munim nyansa munim say asama yeken, we are basically speaking on the issues. The judge should first go back to his or her own hearing, ruling. And no enebechre say sebio asama attachia kano court or chinano etasum and tasum. Because with respect to attachia asama deba, it's all about written submission. And we know the honorable judge or the case we know, he or she he has spoken or she has spoken on this witness written submission. Now, let's do this before we go back to her ruling because Enona, with all due respect, we are putting out that the judge should consider her own ruling. Because if we sit in Ghana and we are in a country where Obia to me criminal case, now eka 2 weeks my judgment aba. Now obey use this same precedent as a defense to fire their lawyer to get a new lawyer there. Then no case will end in Ghana. Say, and the court not allow this kind of abuse. The court not allow it, Wontumi lawyers to abuse the court in this way. The issue here is a day will come. Nipe bi edit begina court. One, obe delay court na for 2 years. Now, it do 2 days. Now you betrone judgment. Obe catch the Ghana for you say we changing a lawyer. Okachen say we there. I didn't know I say also imbrebi, and with law it's all about precedents. Imbrebi Ghana law court ya. Nandi pebi wo court. Na aka 1 month my the judgment aba. Oka say we changing the lawyer. Emma court ji to muma sebio yesa start case. So this is a very dangerous path we are taking. And we are not supposed to allow Atachia to hide behind something called a written statement or written addresses. Now, written addresses now Atachia ko jina ho court or channel. What does it mean? Before I read judge, the ruling when Apia Kubi ekoka chene se onye chema Wontumi lawyer biemu no. The judge na kasa fa ekafa written submission ho. The judge herself or himself record him. Now, let me show you this. The main legal basis written submission come from. Now, written submission any day, you case we na judge a lawyer and can say, "Me a lawyer to Kevin Taylor, make share my opinion on the case." Any friend written submission. Now, a High Court or Civil Procedure Rules 2004 CI 47. This is what it says. In civil cases, the rules allow the court to direct parties to file written addresses submissions after evidence. It is therefore procedurally mandatory once the judge orders it. It is therefore, and this is in civil cases, the case we are faced with in court today, a criminal case. So in civil cases, any criminal cases, it is therefore procedurally mandatory once the judge orders for it. It is a civil case, say judge orders me per written submissions, that one you have to do it. And that only applies when it is civil cases. In civil cases, as I didn't see. Now, criminal procedure practices. So when it comes to civil cases, what happens is the civil procedure rules, which is the 2004 CI 47. In civil cases, any criminal cases, Chairman Wontumi case were a criminal case. In civil cases, when the judge orders for written submission from the lawyers, it is an order and everybody has to put it in. Now we are looking at Chairman Wontumi's case, which is the criminal case. The distinction is very important. criminal procedure practice. In criminal trials, there is no universal statutory requirement. In criminal trials, right now, attaching or lawyer to Chairman Wontumi, he's trying to make it mandatory. This is a criminal trial. Written submissions are not mandatory, and the judge's ruling, she said it or he said it. But the reason to attaching Channel say he is a lawyer to Chairman Wontumi who is facing a criminal case, right? Now, the law actually say in criminal trials, there is no universal statutory requirement that written submission must always be filed. There is nowhere just a criminal case, what we call written addresses must be filed. There is nothing like it always has to be filed. You can decide not to file it. Nobody cares. Because at the end of the day, it does not affect the evidence before the judge. That evidence, the judge, I call it the judgment. This is a criminal case. Now, when you read further, that's what it says. However, courts increasingly use them as part of fair and efficient trial management, especially in the complex or document-heavy cases. So, optional. It does not say it's mandatory. It's saying, no universal statutory requirement. It is not a must. Attaching when he goes to court tomorrow and say, Judge, mommy, 6 weeks, I need to write my written state addresses. It is not mandatory. And the court is not supposed to grant it. Because without it, the judgment can still be read. So what attaching is going to do tomorrow, our court in front of the judge, the judge herself or himself about 2 weeks ago made it clear her point. And I don't think, with all due respect to the judge, with all due respect, I don't think that judge will eat her own words back. Now, when you do a little bit of reading on this same judicial discretion, now, judicial discretion, and this was still under this 2004 CI 47, it says judges in Ghana have wide discretion to, 1, order written submission. Judges in Ghana have wide discretion. And we say judicial discretion. Judges on the deciding. When you say discretion, send your wow pesa we one kasa jumba opese ekoso enyamra and a show. So, your friend, judicial discretion. Judges in Ghana have wide discretion to order written submission. So, the judge could decide or can decide not to order for any written submission. 2, set timelines. The judge can decide not to set timelines and can decide to set timelines. 3, or proceed without them if unnecessary. The judge can go ahead and write their judgment without written submission, without the lawyer's opinion, without the lawyer's own understanding of the proceedings. The judge can still write their statement without even asking for any written submission. In fact, it is an option. It is not mandatory. What Atachia is trying to do, Atachia is trying to force the court to do something that is not mandatory. What is happening right now when it comes to written submission or addresses is optional. It is only in civil cases. And when a judge demands for it, even that one, the judge has to demand. In a civil matter, it is the judge who has to demand. But in criminal cases, no, it is optional. Now, let's go back to this same judge. When Apia Kubi echoed the Nimko and say, I don't want to be Chairman Wontumi lawyer again. And that Chairman Wontumi has a new lawyer. And that stop your judgment because Chairman Wontumi has appointed a new lawyer. What did the judge say? And let's be fair here. This is a judge for a long time. Wa accommodate the Chairman Wontumi. Wa accommodate all the things Apia Kubi. Now, it looks like Atachia wants to take over from Apia Kubi in this kind of cunning delayance when it comes to this criminal case. Now, let's go back quickly. I had now say pay all the attention. And it's about Judge Nankasa or no time Apia Kubi Bejina the Nimka say me lawyer match ma want to be they say Atachia never into delay with judgment. Then a judge we Ankasa kan. This is the same judge with respectfully. Ochina Atachia Eko Jan and him say or no Atachia demanding because at this point Atachia is demanding Atachia is telling the court that the court needs to do that. But in law, in Ghana's legal law, the issue is it is not mandatory in a criminal case for written submissions to be demanded. And I say, without written submissions, a judge cannot go ahead and pronounce judgment. No. Now, so already judge nankasa ne Samuel the ruling when it comes to day na apia kubi echo the nim na. In fact, let's read this one. Eho ena me bia me read this document where me de read efa ho no. Then a judge ne kan time apia kubi ko ne nim say onye de onye chairman Wontumi lawyer bim. E then a judge ne kan. This is the ruling from the judge. This is a few weeks ago. It's moment we judge in the position on a written submission. And sana ochina attaching a court. Ako kache judge and say because of written submission, judge into judgment and shada. Let's see a year the judge nankaso case when she was or he was ruling on that appear could be issue. What did she say? What was her opinion, legal opinion on written addresses? Now, I'll say, consequently, since filing of closing addresses is optional, time na appear could be catch a judge and says, see, I mean, chairman Wontumi lawyer beam, attach an obano, says, no, or then a eba betro written addresses into a journey case, no judgment, no, to another date, send a judge the catch and see. Consequently, since filing of closing addresses is optional, and not a function of the rules, that is to say, there is no provision under the rules compelling the lawyer for an accused or prosecution to file an address. According to say, addresses are optional statements made by lawyers. Listen, written addresses are optional statements made by lawyers to articulate on the merit or demerit on a case one way or the other. Or see, what we call written statements are optional. In fact, those written statements, they are done by lawyers to what? Tell people their opinion, to articulate their opinion about the whole game. It is like a press conference. Technically, written submission or addresses which lawyers write after cases are heard, evidence are provided. In criminal cases, they are optional. It is basically the opinion of the accused's lawyer or the defendant or the prosecution. At the end of the day, it's just an opinion they are expressing. This is like post-match interview, post-election interview. Written addresses are just court interview. It is the same as somebody going to court today. Appear could be court and then we appear but not journalist able to question. It is basically daily written submission or addresses. Appear could be every day he walks out of court. He meets the press. That is the post court proceedings or press, his views, how he articulates, how he sees it. The merits and demerits. Oh, and the court, na be fine. And the moment the judge, I just want that is his opinion. And that is the same thing here. It does not affect what actually transpired in court. The evidence that was put before the judge, the evidence that was put before the judge by the accused or the prosecution. No, it is just his opinion. That is why during this judge's ruling 2 or 3 weeks ago, he or she was clear that written addresses are post-court addresses. They don't affect what actually happened in court. They don't affect the evidence in court. It is the opinion of the lawyer. So the question here is, if it is just an option, it is the opinion of the lawyer, how can it affect the evidence put before the court? Because post-court reaction is done daily. Now, it is all the post-court reactions that you have seen from day one appear could be court opie ochena adwene and no optionally he can decide to put all together in one big document and say this has been my opinion from day one. Every single day I share my opinion, but today I am going to put everything together. I'm going to summarize, compress it for people to know my opinion on the whole proceedings. So submissions or addresses by lawyers do not or cannot have an effect on judgment. Now, already judge in the last statement or say the court would by this extend the time of filing written addresses from 17th of June to 24th of June 2026. For the avoidance of doubt, this matter is adjourned to 9 a.m. on the 3rd of July 2026 for the court to deliver judgment in this matter. Meaning, the judge herself or himself made it clear, I don't care about written addresses. I don't care about posts, court addresses. What I care about is that I've given a date, and that date, the judgment will be read. And see, what I'm trying to say is say, I'm just asking the judge, is she or is he going to eat their own word or his own words or her own words? Because we didn't know this until the judge sitting on that case told us that when a lawyer, after every single court case, walks out of court to share their opinion, is basically a written or oral written address. Now, the judge made it clear that those things are optional, not a function of the rule. When they say not a function of the rules, it means a court say without written submission or addresses, a judge cannot go ahead and pronounce judgment. No, that is the statement. That is the meaning. Inti, the question here is, Ochina, attaching echo court to say, Yanko extended time, Omano, all because of an optional written submission. At the end of the day, why should the court, with all due respect to the judge, at the end of the day, why should the court even hear Atachia out? Because, so we read the judgment now, she even gave Atachia enough time to also write their submission. Now, when you read the last part of a judge ruling now, or say, the court will by this extend the time of filing written addresses from the 17th to the 24th, meaning the judge, nobody was compelling the judge to even extend the time of written submission. It's an option. If you want to write it, then I'm giving you time to write it. If you don't want to write it, I don't give a fuck about it. But a judge in her own wisdom, wanting people to say, at least I'm being transparent. I don't want people to say, oh, I did not even allow it because I'm not supposed to demand for written submission. It is not part of my judgment. The law does not compel the judge to say without written submissions from the lawyers, she cannot or he cannot bring out his judgment. So the question is, why did the judge even give him more? The judge was being more lenient from day one. Much now how they have abused the court. The court was being lenient to Chairman Wontumi and his lawyers. For the judge to even say, I've moved it from 17 to 24th, the judge was even being lenient. The judge knows it is not important. But if it's for the optics, fine, I'll give you 24, write it and go and show it out. So from the 17th to 24th, Atachia could not contact Apia Kubi. Atachia wants to tell me when Apia Kubi was handing over Chairman Wontumi's case to him, Apia Kubi didn't give him the proceedings of the court. Is that what Atachia wants to tell the judge tomorrow? When Atachia was given in room from 17th to 24th, Atachia came back to tell us that the registry did not give him the documentation. So you could see clearly that a plan, the same 442 formation, he wants to continue. It is the abuse of the court. So with me, or when you ask us, Loud Silence Media, my editorial team, we believe that the court should not even listen to Atachia. Because you see, let's be real, let's be real here with this matter. Say me a criminal case that me so ne. If I'm being accused, we are talking about Gift Owari is being accused of criminal things in Ghana. Obi to say a SkyTrain, a criminal case. We are talking about a buffer stock, a criminal case. There are so many criminal cases at Air Court. The lawyers are watching. And with all due respect, I am talking to the judge. You yourself said that there are no rules binding you at the end of the day that without written submission, you cannot come out to your pronouncement, which is fine. We understand, we respect that. Now imagine, all these smart lawyers are mere lawyers to these accused criminals, trial, and then what they are going to do is, if tomorrow, Sir Judge Way, knowing that written submissions are optional and not mandatory and no law in Ghana in the legal framework, is mandate any judge to say without written submissions, I cannot come out with my judgment. If tomorrow, say judge way 80 attach 6 weeks, go and write her. What is going to happen is all the criminal cases we are seeing in court, and we are working with precedents here. This is legal field. We are talking about precedents. Edubuahen money ade. Lawyers in there. Edubuahen lawyer she. Skytrain lawyers she. Give to a warrior lawyer she. Buffer stock lawyer she. All the criminal cases in court today are oral. Lawyers she. Remember, say judge way, with all due respect to the judge, Ochina decided to be granted attachment 6 weeks. So uncle now Abra Odim say any mandatory from her own ruling. No, what is going to happen? And say some cases when they will drag it. Now lawyers of these respective cases will drag the case. Eka 1 month. Not judge, in the judgment about. They will come and tell you, the accused will tell the court to say, you know what, I don't want like my lawyer again. And that I am bringing you a new lawyer. And what that lawyer is going to say is that I am basing my application on that application that was granted when Atachia took over from Apia Kubi as a new lawyer who was given 6 weeks. So me too, right now, the accused has changed his lawyer. I am the new lawyer. I am also telling you, and court is all about basing on your statement on facts and evidence. All the lawyers are going to wait. So Ochina, if this judge respectfully, this honorable judge says, oh, Atachia 6 weeks, all the criminal cases, we will never finish the cases. I'm telling you. All those cases, none of them will be concluded in Ghana. Because all that you need to do is that, as an accused person, get 4 lawyers on standby. Every time your case is echo close, no change new lawyer, another one about you know what, I need to go back and look at the whole case again. So, with all due respect, my lord, give me 6 months. I need to go back because this case has been in court for 3 years. I have to go back from day one and analyze. Or koba wie na also 2 days my judgment about or say I don't want to work with this client again. Now another lawyer about. Can you stop them? No, because the precedents have been set. Because you, the judge, with all due respect, you created that room. You have created that hole, and all of them are going to use it. Let me tell you, when it comes to cases in court, you know the Gamanches case in court. When my case was in court, the smart lawyers of the Gamanche basically. Some of their argument in court was based on my case in the Supreme Court. Yeah, you know, go and read. Because no case is stupid case. So all these criminals, they are lawyers. They are sitting and they are waiting. They want this judge to open that window tomorrow. And you will see what will happen in Ghana. No criminal case will end in Ghana. Because if they are presidents, you cannot tell me you won't give me that. Why did you... the court, and at that point they are not looking at you, the judge, they are looking at the court as a body. Until when you refuse to give them, they will go to Supreme Court, they will go to appeals court, because why did you give Kevin Taylor, you don't want to give me? And this is law. You cannot say that, oh, the last time the judge gave, I cannot give. No, the lawyers will say, me too, I am changing, I have been changed. You need to give the new judge, the new lawyer, that 6 months, 6 weeks, and it's going to be part of our legal framework. It is dangerous. The moment Atachia is granted this tomorrow, our legal system will break down. No criminal will enter jail. No criminal can be prosecuted. No judgment can be read in Ghana, because now all that you do is you wait. Judgment to bar. Eka 3 days, no change new lawyer. Who change new lawyer and new one bar? Or say, please, let's start from beginning. Okay, so on TSS, no, let's go back. The president, it happened in 2026. Atachia took over from Apia Kubi, and he was given 6 weeks. The same court. Why are you choosing today? Now I'm going to go to appeals court. I'm going to appeal that 6 months. So we need to be careful. And I believe that Ochinano, this judge, I don't know this judge, but I believe say or a one smart judge or wabutra or a very transparent. And the lawyer for Chairman Wontumi onim dia oye. Let's not create any room for these people to destroy our judiciary. Because Ochina, your boy whom is a mistake. Ne ka say, oh, Apia Kubi and a dema attaching go 2 weeks. Even 2 weeks is dangerous. 1 day is dangerous. I am telling you. Because all these criminal lawyers, all these lawyers defending these criminals in Ghana, they are waiting. Obuha, or you said the next 6 months, ni case no judgment beba or train. Obu in the next 1 year, onim say the case no judgment beba. Obu okra onim say in the next few weeks, judgment beba. They are waiting. Tomorrow, if this judge grant Atachia this, no case will end in Ghana. I'm telling you. And you see why the MPP is doing this? Adikudientia omu side within say they know that the MPP they have an election. And NPP to conduct national executive elections between September 18th and 20th. Now, on the Atachia up 6 weeks. 6 weeks, it will enter into August. Now, you can even say, oh, now said this one, August, this September, this is what they are trying to do. So we wait to free what is happening, and they say, the judiciary in Ghana, the Ghana judiciary's major annual break, the long vacation is about to happen. Officially takes place from August 1st through September 30th. Now, Atachia will have 6 weeks. It will enter August, August 1st. Meaning, technically, there will be legal vacation. The legal vacation takes about September, about 3 months. Odianya is limited 2 months. Meaning, for the next 2 to 3 months, there will not be court. What is going to happen is, it means during this period, superior courts are generally on break, but selected courts, typically within the law court complex in Accra, are designated to sit on rotation to handle urgent and pending cases. When they say selected court, it could be that where Chairman Wontumi's case is not part of the selected court, meaning Chairman Wontumi's case will never end. There are two things now attaching pushing this case to MPP primaries. Now, Chairman Wontumi, then the conversation would turn around. Kofi Benton and Kwasi Afoma now. Oh, you see, the national chairman of the MPP, Chairman Wontumi, is being persecuted. They want to print that message out. They want to create that impression that the NDC government, when they came into power, a criminal who was involved in illegal mining, where he was put before court with all evidence showing, hey, that guy is the national chairman of the MPP. So to them, it is not about the law being applied. To them, it's about using the law against us to protect their criminals. And the judge, given 3rd of July, the judge should not, even holiday crowd also set it, not already judgment in the Ghana for. Because a mistake. They allow this judge, with all due respect to the judge, a mistake, not judge now allow this to happen. Atachia is not here. Atachia does not have any evidence to protect Chairman Wontumi. Atachia onim law papebia. Atachia is somebody coming in to delay the court, to disrespect the court, to frustrate the system. So what they want to do is, they want to go for their conference or whatever quickly. In Tomukope, fast. Na yanyi Chairman Wontumi, because Chairman Wontumi, the guy I'm saying Sikali or the share Bawumia campaign, we all know Chairman Wontumi works for Bawumia. And Bawumia is the one manipulating the party now. Onona Oshe so omunya pam de Japan, because onene yere no person on the party come charge for. Now what Bawumia is doing now and say Monya nentam mama attach yanko delay Chairman Wontumi case no court. Send a baby to my primary no not delegate na be Chairman Wontumi. Send a baby Chairman Wontumi ruling ne bana ebia etiana. Ne akache wi ase nyina say the national chairman of the NPP is being persecuted. But we all know Chairman Wontumi, what he has done, the reason why he's in court. Mamu Maya allowed the MPP to destroy everything. And I'll plead with the judge, with all due respect, Mr. Judge or Madam Judge, with all due respect, this is a very important case. Memenko Law School, so many people watching us, we have not been to law school. So far from the day this case started here, everybody has seen the transparency, the honesty of the case way. My interest is not to see Chairman Wontumi in jail. My interest is to make sure the right thing is done. Evidence, you write a judgment that nobody can contest. So I'm not here forcing anybody to jail Chairman Wontumi or let Chairman Wontumi go. My job here is to explain the process. If we are building, if we want to protect this nation, we need to do it right. Let's not allow some people, because of their political greediness, destroy the last pillar. Because the judiciary, basically, is the only thing that, at this point, some politicians are scared of. If we go tomorrow, we listen to Atachia and we force Atachia, forces himself on us lie to the court, and we basically swallow our own ruling and what the court is against. That is why I've read your own ruling to Ghanaians. And I know a judge like you with all the experience, say for once, and a nipa could be able to accuse you of anything. You have shown professionalism. Please, let's show this professionalism. Let your word be your word. Let your word be your word. And your word is that written submissions are optional. Written statements from lawyers does not affect judgment. In civil matters, a judge can mandate for that. In criminal matters, you said it clearly, nowhere in this world. And a written submission, a mandatory. So at this point, you have made us understand it is binding. Written submissions are not mandatory. You can go ahead and pronounce your judgment without even listening to Atachian. Atachian's post-court analysis, it's to his own benefit. It's his own opinion, and he can exercise it whether today or tomorrow. He has the right to do that. But the law, the court, only recognizes the evidence before you and the date you have put out. We will meet tomorrow. We will discuss Ghana. We will make it clear. Ochina, a year Attorney General will be in court. Ochina, a year we will all monitor. And remember, you know one interesting thing? Atachia he's trying to lie again in court. You know? He's the lawyer for Edubuahin. So, Madam Judge, Mr. Judge, you see what they are trying to do. If you listen to Atachia tomorrow, and you grant Atachia 6 weeks, 2 weeks, even 2 days, the same Atachia will go to court and cite this same ruling by you tomorrow, if that is where we are going to go. Because Atachia is a lawyer for Edubuahin. Edubuahin's case is close. They are about to end the case. If you give Atachia this, which you know, and you have said to us that it is not mandatory, so because Atachia enco 6 weeks, enco written submission to judgment in Ba. Remember, Atachia is the lawyer for Edubuahin. And if you give Atachia this, when Edubuahin case ebedu and the judgment is about to be read, Atachia will step away, bring in Apia Kubi, and Apia Kubi will tell you that, do you remember this court? Because we are dealing with the court, not individuals. They will go to court and say, does the court remember that during Chairman Wontumi, Samra Boy criminal case, Atachia, who is now not Edubuahin's lawyer, contested that written submissions were important and that judgment was supposed to postpone. Do you understand? They will cite that. It will be the precedents they will be using. Atachia is setting 2 goalposts for himself. He wants to shoot without any goalkeeper in them. And that is what he will start from tomorrow. Let's not give them that. Especially when you, Mr. Judge, Madam Judge, you have made it clear that written submissions does not affect judgment of a case. Meaning, there is no case here for Atachia to make tomorrow. Meaning, Ochina, there is no case here. This guy is the same lawyer for Edubuahin. He will basically take Edubuahin to the final day and say, I'm no more his lawyer. Let Apia Kubi come take over, and Apia Kubi will cite Atachia's decision you are going to make tomorrow. So the best for us all as a nation, now that the law says it clearly, that written submissions in criminal cases are not mandatory, not important. Madam Judge, Mr. Judge, with all due respect, tomorrow, let's quash this nonsense and then come out with your judgment on the 3rd of July. My name is Kevin Akobe-Rutila. It's been a wonderful Sunday evening. Tomorrow, we will be live in the evening to update you on what comes out from court tomorrow. My name is Kevin Akobe-Rutila. Be good. God bless you. God bless you. It's exactly 6:41 p.m. U.S. East Coast time. It's 10:41 in Ghana. Have a wonderful night. Abuache. Gi. Gigim.
Yo! We are best fishermen. No, no answer mine. I watch it. You will for Belgium Quant. It was a Belgium Quant. It was 2 Belgium Quant. Why you're yet? Why round what? 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 It was for Belgium Quant. It was a Belgium Quant. It was 2 Belgium Quant. It was Belgium Quant. Why you're yet? Why round what? 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 what one is the motto? Yeah, we papa no, what one is the motto? Yeah, we papa no, what one is the motto? Yeah, we papa no, what one is the motto? Why dranga? Why yo yeah? Why dranga? I watch it. Original. I walk for bad. I want me to bad.